In 1940, Congress passed the Soldiers and Sailors Civil Relief Act. They had begun thinking about it during the Civil War. But times have changed, and so has the Act. We'll talk about the Servicemembers Civil Relief Act right now on the LawWorks.
From West Virginia Public Broadcasting.
Closed captioning for the LawWorks is made possible by a grant from the Monongalia County Bar Association to support legal information and education for all West Virginians. The LawWorks is made possible by major grants from the Office of West Virginia Attorney General Darrell McGraw and from Software Systems Incorporated, a West Virginia company established in 1975 which provides high-end support services, programming, and consulting for county government AS400 mid-range computer systems as well as PC-based systems, and by a grant from the West Virginia Bar Foundation. The West Virginia Bar Foundation, the philanthropic organization for West Virginia's legal profession and justice system, promoting public knowledge of the law in West Virginia.
The Servicemembers Civil Relief Act was enacted so that our soldiers are not disadvantaged at home because of their commitment to our nation. My guest is West Virginia National Guard Judge Advocate General Major Brian Abraham. Brian, thank you for joining us.
Thank you.
I mentioned that you're a member of the National Guard and a Judge Advocate General with them. You also have a private practice here in West Virginia.
That's correct. I've been in Logan all since the time I've graduated from law school. I was the prosecutor down there for about 10 years, and in 2008 we opened up a firm, Abraham and Elderton.
How long have you been in the National Guard?
I've been in the Army Reserves for 9 years. I recently joined the West Virginia Guard in June of last year, transferred from the Reserve.
And you've not always been an attorney when you were in the
I was direct commission as a first lieutenant as a judge advocate in 2003.
You were?
Yes.
Okay. What is the Servicemembers Civil Relief Act?
Well, as you point out, it's obviously a federal statute that deals with the protections afforded certain service members depending on status as it relates to mostly civil affairs when it comes to lawsuits and other things such as leases and interest rates and stuff like that. There's several protections built in.
Why do we need something like that?
Well, Congress passed it, as you point out, many years ago in response to, as was once quoted by the Supreme Court, that those that should not have to put aside their affairs that answer the call to duty. And those that are serving on active duty or in a mobilized status are obviously at a disadvantage in dealing with things that are going on back here, and that's the purpose of the Act, is to level the playing field, if you will.
Does it apply to all the branches of service?
It applies across the board to all branches of service. One of the important things to remember is what's the status of the service member. For instance, if you're on active duty, certain provisions may not apply to you versus if you're a mobilized soldier. For instance, if you enter into an obligation while on active duty, such as a lease on an automobile, you can't then later invoke the Act to get out of that lease. But a person such as myself that's a reservist that may have a lease that I've entered into and then I'm mobilized to active duty, I can void that lease, turn that automobile in or that lease on a certain piece of real estate and void it for that reason. But a person that's already on active duty, you know, they're really not changing their status or situation. There's no point in allowing them or no benefit to them to invoke the Act.
So if I'm on active duty and I'm stationed at a military base here in the United States and I enter into a contract to do something, I'm not going to have any advantage or any do-over as a result of being in the military.
That's right. Now, obviously, if there's some issue with breach or something and litigation ensues, you may have rights to enforce if you're mobilized or if you're deployed or something like that to stay the proceedings. But as far as going in and voiding contracts that you might be able to do as a mobilized reservist would, those protections aren't there for active.
Okay, let's define some of these other basic terms because people can get confused. There are civilians and there are service members. Then there are civilian soldiers.
Correct. Like
members of the Reserve and the National Guard. And they get called up. And in recent years, some of them seem to be called up all the time. They have some advantage with the Servicemembers Civil Relief Act.
That's correct, and I would be an example of that. Right now, as a member of the West Virginia Guard, I serve in what's called Title 32 status, and that is I wear two hats. I answer to the governor of the state of West Virginia, and if I'm called to active duty, I also answer to the President of the United States. If I'm actually mobilized to active duty in service of the United States, then I'm serving on what's called Title 10 status. And that's what you see most of the active duty people are obviously on Title 10 status. So,
okay. So mobilized means to be called up for a military purpose and you go to work as a soldier as if you were on active duty all along. That's
correct. Now, that I guess draws a distinction between the Army Reserve and the National Guard. Army Reservists is always on Title 10 status because they're always serving at the interest of the United States. West Virginia Guard members serve both at the pleasure of the governor of the state of West Virginia and can be called to active duty service in the Armed Forces Reserve of the United States. For instance, if we have a natural disaster here in West Virginia and the governor chose to call up National Guard members to clean snow or work in the floods, what have you, they're serving still on Title 32 status at the will and pleasure of the governor. If those service members, as you know, in past years have been called up to go and serve in Iraq or Afghanistan, they're serving on Title 10 status in federal service. So there's no real distinction there for the Soldier Sailor Relief Act because we can certainly, as that mobilization occurs, afford ourselves the benefit of that act.
So the governor or the National Guard is sort of the governor's army unless the president needs them.
That's the easiest way.
He will say, you're mine now.
That's right, yeah.
And of course, if you're sent overseas, then you are identically as if you were on active duty through the whole thing.
There's some slight distinctions as far as personnel matters go, but that goes
but
well
for our
purposes,
purposes,
for the purpose of this show.
that's the same thing.
Correct.
So if I'm a civilian and I lease an apartment or a house or a car, and then I get called up, that can make a major difference in my ability to pay bills, pay mortgages, things of that sort.
That's correct. So using myself as an example, my military pay would not be equal to what I'm able to make as a civilian attorney. So if I'm called up involuntarily and have to serve again, then I'm allowed to offer those or take advantage of those protections. I can reduce my mortgage interest rates, although we've had that conversation. The statutory amount's 6%, and often now mortgages are below that, so that one's not. But credit cards can certainly be reduced to a 6%
Credit cards can be
rate.
18%, 24%,
reduced.
Even higher than that
Correct.
in some instances. But the service member can say, I'm on active duty now, I've been mobilized, however we want to call it, reduce my interest rate.
Correct.
And they do.
Correct. And then, instance you entered into a contract to lease a vehicle, you may have a year or two remaining on it. You can usually turn that vehicle in and void the remaining part of that lease. And again, it's all for the protection of a service member who's losing his ability to earn his civilian salary and trading that for a military salary because of his service obligations.
Because you're willing to serve your country will step in and help you out a little bit.
Yes.
With these things. Suppose you're in the military and somebody sues you.
You can then use the act to, not really as a shield, but it does allow you to stay certain proceedings. Obviously won't.
What does that mean, stay?
Stay is if you're unable to appear because of your military obligation, you have a right to file notice with the court and ask for a stay of proceedings that allows you up until 90 days after you're released from whatever duty it is that you're on to then appear in court and defend yourself. In other words, it obviously, again, is all about leveling the playing field. If a soldier's deployed overseas, it's unfair to allow a plaintiff to come into court and sue that soldier and get judgment on him when he's not able to be here to defend himself regarding whatever the allegation would be.
But it requires some affirmative action by the soldier.
It does. They have to obviously provide the court notice that they're asserting the act, and that can require anything from just a simple memorandum to the court, affirmation by that soldier's commanding officer or unit that they are serving on active duty, that they are in a status that would prevent their being able to appear in court and defend themselves. And then most courts are required to stay those proceedings. There are certain exceptions, such as in child custody proceedings. If there's an emergency type hearing, the court can take certain actions without the soldier there. Obviously, as we may discuss later, they can't make permanent orders in effect because of that deployed status. It doesn't work too often, it doesn't work at all to stay criminal proceedings. In other words, if a soldier has a criminal matter, they can't use that to avoid that criminal matter. service will ensure that the soldier returns to answer those issues.
The Servicemembers Civil Relief
Correct.
Act doesn't apply to criminal cases.
That's correct.
I'm talking with Major Brian R. Abraham of the West Virginia Army National Guard about the Servicemembers Civil Release Act. I'm Dan Ringer, and this is The Law Works. So if the service member is accused of committing a crime, he or she has to come back and answer for that.
They will be returned to answer to those.
One of the real possibilities I see is that a service member who's young, a quiet member of the community, not particularly well known around town, for example, might be called up to active duty or mobilized and goes and reports wherever it is he or she is supposed to go. And nobody's particularly aware of that. But someone has a problem that they want to try to hold that person responsible for, so they file a lawsuit. They can't find him because he's on active duty. They don't even particularly know he's been called up. So the service member never receives a copy of the complaint, never knows to write to the judge or to go to somebody to get help, and the case just goes on. They get a default judgment and it's entered against him. What can he do?
The Act does have certain provisions in it that allows one to void a default judgment if in fact they were under the protections at the time the default judgment was entered. They have a certain amount of time once they receive notice of the default judgment, 90 days is typically the standard, to come in and then use the Act or assert the Act to maintain their interest.
So it's 90 days after the entry of the default judgment, or after they find out about it?
After they find out about it, or 90 days after they're released from the active duty. So the 90 days, it's whichever occurs later. So if they get off active duty, they were aware that during somehow mom called, dad called, said, hey, somebody's got something. Once they're off active duty, they have 90 days to come in and try to set aside the default judgment asserting the Act.
Okay, so there is relief for them if they're called up in the middle of the night and are hurried out. And some service members are activated very quickly.
Oh, no, yeah. It's not a situation where you might get called up today and tomorrow you're in a foreign land, but obviously there are times when you might get some shorter notice, be called up, serving even on a state basis, or called up. You may be transferred to what's called like a training station in a short period of time, where you may spend several months there training for deployment, which would still take you outside the jurisdiction of this state, so you may not know that you've been served. You know, the letter came to your apartment or somebody signed for it for you, something of that effect in relation to your scenario. So that does come into play.
How long do you have to be called up for?
Typically, it's on active duty for at least 30 days. That kind of puts you into the as far as reservist goes, that's when you're really on active duty. It doesn't necessarily apply to active duty for training purposes. That's not what the Act's for.
No, the Act is when you are
mobilized. It's there's we do our 2 weeks during the year. You might do a little bit more training than that. That's not what the Act applies to. You can't do it for active duty for training. It's active, being mobilized to active duty.
Suppose the soldier is in a position of saying, well, I understand that there is this case. I don't want it to drag on for 60 days, 90 days, 2 or 3 years. Because we do have service members who have been called up and have been on active duty voluntarily or involuntarily for a period of years in some cases. Suppose they say, well, I want to engage in this, but I can't come back.
They can provide somebody with a power of attorney who can appear on their behalf. They could obviously engage an attorney who can appear and represent their interest. And then, again, you have to assert the Act and to get the protections of it. So if they choose not to do that, certainly it's not an absolute bar to any kind of proceedings.
In an awful lot of cases, when attorneys file pleadings, one of the paragraphs they put in the document that starts the legal matter, typically it's called a complaint or even a petition, there will be the paragraph that says the defendant is not an infant, incompetent, member of the active duty military or subject to any other infirmity. Being on active duty with the military is considered to be an infirmity or to create an incompetency under the law. Doesn't mean there's anything wrong with you,
right,
except that you're on active duty. And sometimes we're wrong if we say that and the person's been called up. We just don't know.
Right.
But there is relief available for that. Probably the most common question that I get, and I get calls from JAG offices who have a military member sitting there who has been sued for divorce or I get a call from a spouse whose spouse is on active duty with the military, and that is, how can I get a divorce, or how can I keep from getting a divorce? I'm in the Army, or my husband's in the Army, or my wife's in the Army. How does all of this affect divorce?
It plays a lot into, obviously, jurisdiction and venue. And I get several of these cases in my civil practice every year. And as we discussed, kind of comes in two forms. One would be the soldier may go to basic training, come back, marries his high school sweetheart, goes back to wherever his next duty station is. She may or may not follow him, and I don't mean to use gender as this, but they may follow that service member back to that duty station or not. So that affects a lot when it comes to whether, you know, our state or any state would have jurisdiction and venue over those parties to grant a divorce. That's one of the first issues you have to consider. You know, and then of course, what is the soldier's or service member's duty status? Are they just serving on active duty, but they may be in just another state at a duty station, or are they actually deployed overseas to where then there's obviously separate issues about them being able to appear in court and things like that. You know, typically we find, as I'd said in our practice, a lot of the marriages in their infancy, if you will, and maybe there's been a change of mind just after several months, and those are a little easier to deal with. We find more involved cases when we have kind of retired service member issues. Of course, this act doesn't apply to them. But that's most of the divorce cases we see. But again, jurisdiction, venue kind of things are pretty much the first issue you're going to look for if one of these comes into your office.
I'm talking with Major Brian R. Abraham of the West Virginia Army National Guard about the Servicemembers Civil Relief Act. I'm Dan Ringer, and this is The Law Works. You talk about jurisdiction. Jurisdiction means the authority of the court to actually hear the case, and in this case, divorce.
Correct.
Now, there are requirements that have to be met before a court has authority to hear the case, one of which is residency. And I have seen situations where he and she get married while he or she is home on leave. They immediately move together to Kentucky, where they live for 6 or 8 weeks. He gets deployed to Afghanistan or someplace. She decides to go live with her sister in Indiana. She finds out 6 weeks later she's pregnant, so she can't live in Indiana anymore, so she goes home to mom in Ohio. And it just gets to be a confused mess. And in some circumstances, you will find that this couple is not entitled to a divorce anywhere.
The issues, obviously, in the way West Virginia terms is domicile, and that is where, you know, what is my true residency? You know, I may move from place to place, I may establish a home, that may not be the place I intend to permanently reside. So the question is, what is domicile? You see that a lot in the military. A person may be stationed in a particular state, but obviously they may claim their home state as their actual state of residency for tax reasons, or they don't intend to actually, just because of their military service, change their domicile.
Actually, many decades ago, when I was in the service, I paid West Virginia state income taxes. I licensed my cars in West Virginia because I knew at some level I was going to come back here and go to graduate school or professional school, and I didn't want there to be any question about where I lived, was I a West Virginia resident. So I thought that was cheap insurance to keep that question from coming up, and I never had any problem with it.
So you do find a lot of times a spouse may follow a service member to another state, but they've never changed their driver's license. You know, a lot of their bills still come back here, and they often, as you point out, come back home. And in those cases, you can pretty easily argue that they didn't intend to change their domicile, and therefore, you know, jurisdiction is something you can usually get your hooks into.
If you can.
If you can.
The important part of this is if your spouse is in the military, or if you and your spouse are in the military, you really need to find an attorney that you can talk to when issues concerning divorce, child support, things of that sort come up. And that can be difficult to do, because there aren't a lot of lawyers, at least in West Virginia, who are terribly knowledgeable about these things.
That's right. We obviously have no active duty installation here in West Virginia, such as an air base or a fort or anything of that nature with a sizable military population, where we, in this state, have our Guard members and our Army Reserve units. And because of that, you typically don't see, you know, a great number of these cases come in. And for that reason, attorneys, you know, don't normally bother to delve into these issues on a frequent basis, so they don't even bother to learn it. You kind of get your book out and try to catch up to speed when you get one comes in the door.
But we can provide you with some help. There is a phone number. If you run into a question or think you may have an issue that you need an attorney's help with, I would encourage you to consult with attorneys in your community, but you're unlikely to find somebody who can answer quickly or easily some relatively obvious questions to someone such as yourself. We have a number that you can call. For more information about the Servicemembers Civil Relief Act, you can call 304-561-6323. 304-561-6323. And also, if you know where your spouse is stationed, you can call that base, that facility, and ask for the Judge Advocate General's office or the JAG office. Everyone will know what that means. And they'll connect you and you can answer your questions, because it can be very difficult to get information.
That's correct. I mean, there's a great many issues you're dealing with when you're, especially in the context of family law, when you're talking about service members. Everything from where actions have been initiated to what happens until they have been. Can I get relief? Do I get some temporary child support or something like that until I can get divorce filed? Those are all issues that have to be dealt with. Of course, there are answers to those, but each of them have to be kind of addressed separately.
Well, the age-old question is, my husband's in Afghanistan. I don't want to be married anymore. Can I get divorced?
You can file, but then there's an issue of whether or not they're going to seek the protections of the Act. Most likely is you would not be able to finalize that divorce until they return from that mobilization or that tour of duty and can appear in court and defend their interests.
Well, he's not sending me any money for the kids. He's not sending me any money for myself. I'm getting ready to lose everything. Can I get some support?
You can. That's a different issue. Typically, you call the unit commander, and you may have to start at the higher part of the chain till you can work your way down to actually find where he's at. But if a unit commander under current Army regulations discovers that there's a separation and the spouse is seeking some kind of support for the children, absent an order, that commander can order that soldier to provide support to that spouse, and it's an amount up to his BAH with dependents. So the soldier's receiving that amount in addition to his pay. The commander can order that soldier, service member, to provide that to the dependent spouse.
What's BAH?
That's your housing allowance, basic housing allowance. So then it varies versus a single soldier versus those with dependents. It's a different rate, but that is what a soldier is paid in addition to. And I shouldn't use the term soldier. I'm an Army man, so it's soldier. But a service. If
you're in the military, you can be an airman, you can be a sailor, you can be a soldier.
Service member.
Let's just call them soldiers.
Okay, but that is the amount they receive in addition to their base pay that provides for their housing and allowance.
And that's, you can get that while you're waiting to get into court for a temporary order.
Correct. And when there's actually a marriage involved and paternity's not issued, things like that, yes, they can contact the unit commander. That commander would order that soldier to provide support to his dependents, and if he does not do that, then it's a violation of a lawful order, and then punitive action can be taken.
So the commander says, I order you to pay this amount of money according to our charts here.
Army regulation,
and
yes.
Either you do it or we prosecute you for insubordination.
Correct.
Failing to obey an order. Once you get a court order, can that order be enforced?
Yes. Once there's an order, the Army obviously, or any service, again, I keep using Army because that's what I do.
Well, you are.
I am. They will honor court orders, yes. And then the actual garnishment can be taken once there's orders entered. In other words, just the same as you would with any kind of withholdings.
Well, the soldier says, I admit that I know that woman, we were never married, and that's not my child.
Okay. In an instance where there's not been a marriage and there's not been a determination of paternity and the soldier's contesting paternity, a commander will not order support until there's been some determination as to that obligation.
Can you force paternity testing?
Not at this time. You're not forcing paternity testing. That person would have to go to court, file a petition, get an order ordering paternity testing, and then that can be recognized.
Okay. Well, once again, information is available. The first step, we would suggest you call 304-561-6323, regardless of whether it's a divorce situation or otherwise. If it's a question about an active duty service member, his rights, obligations, her rights or obligations, or your rights and obligations as a spouse of a service member, in West Virginia, 304-561-6323. Or if you're elsewhere and you need information and you know the base where the service member is stationed, call the base, ask for the JAG office, Judge Advocate General's office. They will connect you and you'll get information that way. Do not try to go it alone. If you can't find a local attorney who's not familiar with these things, get information. Brian Abraham, thank you very much, sir, for being with us.
Thank you.
Thank you also for being with us. On behalf of the Law Works, I'm Dan Ringer. Good evening.
If you would like to suggest a topic for a future The Law Works show, or if you're a school teacher and would like to receive a DVD of this show for classroom use, send us an email to thelawworks@comcast.net or visit us on Facebook. On the Law Works website at thelawworks.org, you'll find a listing of recent The Law Works programs, additional information about this show's topic, and video of this and recent shows. You can also find the Law Works programs on YouTube and iTunes. The Law Works is produced in cooperation with the Office of the West Virginia Attorney General, the West Virginia Bar Foundation, the Mountain State Bar, the Monongalia County Bar Association, and the West Virginia University College of Law.
The Law Works is made possible by major grants from the Office of West Virginia Attorney General Darrell McGraw and from Software Systems Incorporated, a West Virginia company established in 1975 which provides high-end support services, programming, and consulting for county government AS400 mid-range computer systems as well as PC-based systems, and by a grant from the West Virginia Bar Foundation. The West Virginia Bar Foundation, the philanthropic organization for West Virginia's legal profession and justice system, promoting public knowledge of the law in West Virginia. Additional support for the Law Works is provided by the West Virginia Supreme Court of Appeals.
From West Virginia Public Broadcasting.